Mark?
Thank you, Ari, and good afternoon, everybody. Um, After a month, really, of hiding the ball in this case and refusing to produce any evidence to support the charges they have that Mr. Uh, Khalil's presence in the United States has potentially serious adverse foreign policy consequences, which is what the charge in this case. The government submitted, as you all have seen now, a two-page document, 2 pages. That's it. And in that, Secretary of State Rubio says that Mahmoud's presence here would create adverse foreign policy interests. But what does he talk about? He talks about First Amendment activity in the United States and the effect on people in the United States. His determination, quote unquote, has absolutely nothing to do with foreign policy. This provision of law is something that has been rarely used. It was supposed to be introduced for the purpose of like saying to the Shah of Iran shouldn't stay in the United States. Really, like public figures like that, it has nothing to do. This law was not to be used to go after people for First Amendment protected activity. What the Rubio letter talks about is they're trying to protect, they say, Jewish students in the United States, Jewish people in the United States from anti-Semitism. But what is the anti-Semitism? It is criticizing Israel and the United States for the slaughtering that is going on in Gaza and in Palestine. That's what this case is about. And that's what this case is really centered on. The rights of people in this country, citizens and immigrants alike, who are all protected by the Constitution, by the First Amendment, to be able to speak out, whatever their views may be, popular or not. That's what this country is about. Yet this administration wants to silence Mahmoud, wants to silence people speaking out against the government of Israel or government of the United States. And where would this lead? Are we going to now throw people in jail for speaking out about against the Social Security cuts in this country? This is a dangerous slope, and we are taking a stand on behalf of Mahmoud, and he is taking a stand. He's decided to stay in jail and fight this case to the bitter end while we try to establish that people like Mahmoud have a constitutional right to speak out in this country, and they should not be, the government should not be using this really bogus statute saying it's against U.S. foreign policy interests. Let me pass this on to Johnny now, I guess, to talk about what's going to go on in immigration court.
Thanks, Mark. And I just wanted to jump in very quickly before I hand it over to Johnny, sorry, Johnny, to say exactly what Aaron just said in the chat. If you have questions for our Q&A section, please drop them in the chat and we will get to as many of them as we can. Please note who you are and what outlet you're coming from when you put in your question. And with that, I will now pass along to Johnny.
Yeah, thanks a lot. And thanks, Mark, for setting that up. Tomorrow in immigration hearing, in immigration court, we're set for a hearing where the government will attempt to establish that it's met its burden to show that it can deport Mahmoud for lawful conduct that's protected by the free speech clause of the First Amendment. Now, the immigration judge has already put on the record during our last hearing that we are not, in fact, in federal court tomorrow. And that's a nod to the government's position that immigration judges can't rule on the constitutionality of immigration laws. But in order to comply with due process and ensure that Mahmoud's right to a full and fair hearing is fulfilled, tomorrow should be a full-blown evidentiary hearing and not just a rubber stamp on the government's baseless belief that it can take away Mahmoud's green card and separate him from his pregnant U.S. citizen wife and their soon-to-be-born U.S. citizen child. Now, the immigration judge has also told us that tomorrow she will make a finding as to whether Mahmoud is removable, but we are far from the end of the road if that happens. If the immigration judge determines that he is in fact removable for lawful conduct that is protected by the First Amendment of our Constitution, the case will move on to what's called the relief stage of removal proceedings, where Mahmoud and our legal team will be able to litigate his right to remain in the United States, even though the immigration judge has found him deportable. This process plays out in immigration court, and it will most certainly require several more hearings before a final decision can be made in the immigration case. But regardless of that fact, I think the bigger picture here that we all need to keep focus on is that tomorrow's hearing has momentous implications. Whether the government can act in violation of the Constitution to deport someone is front and center, and our position is that it cannot. And now I'll move on to Bahar to talk about where we're at in the district court proceedings and what this means moving forward.
Hi, everyone. So as you all know, and the attention had been placed earlier, we have a case in federal court in New Jersey that is ongoing and active. And just as the government was trying to manipulate jurisdictional rules to keep Mahmoud out of New York, federal courts in New York and New Jersey, and into the federal circuit in Louisiana, where the law is very favorable to the government. They are also now attempting to leverage the considerable power and authority and the limited protections that are available in immigration court, and to argue that in immigration court, as opposed to in federal court, the court has to largely accept what the Secretary of State has said about Mahmoud and largely defer to the executive's conclusions about the fact that he is a threat to foreign policy, simply because the Secretary of State says, without analysis or evidence, that he deems Mahmoud a threat to national security. This is a sort of a tacky Soviet-style diktat that's like equal parts empty and chilling. So we're going to fight in the immigration court, as Mark and Johnny said, but the reason we have a habeas corpus petition in federal courts is that federal courts have a robust obligation to enforce the Constitution. And enforcing the Constitution means, of course, recognizing and enforcing the constitutional rights that are so centrally at stake in this case. But it also means in a federal court and in our system of separation of powers, we don't have to accept the leader's say-so as the final word. The law requires a federal court to question this determination and ensure that the determination is consistent with basic constitutional protections in the First Amendment. And also in due process. We've talked a lot about what the First Amendment requires, and as journalists, you're all very familiar with it. But there's another fundamental principle here that the government can't just operate on hidden law based on one executive official's say-so. Does anyone here know what conduct they would have to engage in that would trigger an adverse foreign policy interests to the United States? No one does, no one can, which is what's so dangerous about this law, and why the federal court case has to proceed in parallel.
Thanks, Bahar. Really appreciate it. I am now going to start going through some questions. I see a bunch in the Q&A function, so keep them coming and we will go through them and try to get to as many as we can. We also have some other folks from the broader co-counsel team on this briefing, so you might see Bahar, Johnny, or Mark bringing them in as necessary, depending on their expertise. So I am first going to start with a question from Gregory at AFP. Elements of it I've also seen from questions from others. But the question is, what is the chance that Mahmoud will be released tomorrow? And how is Mr. Khalil's state of mind right now? The question also gets into, some questions about just the logistics of the hearing tomorrow. So if whoever is answering could talk about, when, where, how, as well, in answering that, that would be great.
Sure, I'll start. So the hearing is it's a hearing that's physically taking place in Jena, Louisiana, where they ship Mahmoud to in the middle of the night he was arrested, and that's where he is detained. And that's what the government has been doing in a lot of these cases, sending people down to remote locations, away from their families, away from their legal support. And that's where the hearing is taking place. The lawyers will be in various places, including them remotely, but the hearing will be conducted. We had asked that we have sufficient time to review the government's evidence and respond to it. It was only submitted at 5 o'clock yesterday. The judge denied our request to do that, and she scheduled the hearing for Friday morning, or Friday, I guess, afternoon in Louisiana, 1 o'clock. So at that hearing, we will be contesting the evidence. We'll be asking in advance to depose Secretary of State Marco Rubio. We will be asking the government to have to meet its burden. Rubio's letter has nothing to do, as I stated, with foreign policy, and we'll be challenging that in court. What the judge will do with that is yet to be seen. And although she did say, when I raised that on Tuesday in the hearing and said we would be doing that, her response was something to the effect of, Mr. Vanderhout, we're not a federal court here. This is a court of limited jurisdiction. And she didn't say she would deny it, but she certainly did not seem open to it. But we'll see where that goes, because we have the right. Mr. Khalil has the right under due process to confront the evidence against them. And that's what we want to examine Secretary of State Rubio about.
Yeah. And I'll briefly speak to how Mahmoud is feeling. We've been in continuous communication with him. He's feeling confident, he's feeling strong, and he's feeling supported by the community. And he understands that he has done nothing wrong. He is only engaged in lawful conduct. And his wife and his family are sources of support for him. And the support that he's received, not only nationally, but internationally, from people who are appalled by what the US government is trying to do in this case, is giving him the ability to move forward, knowing that the correct outcome will be achieved, whether it's tomorrow or in the future.
Yeah, and I would just add one thing on that, in terms of the essence of this case, and that it is really a challenge to everybody in this country's First Amendment rights. The statute itself, when Congress enacted this, the authors of the statute in Congress was very concerned about whether this would be used against immigrants in this country in violation of what would be activity protected by the First Amendment if they were U.S. citizens. And U.S. citizens and permanent residents in this country have the exact same constitutional rights vis-a-vis the First Amendment. So Congress put in a provision saying it cannot be used against individuals for activity that would be protected by the First Amendment if engaged in by U.S. citizens, unless there is a compelling government interest based on foreign policy. And Secretary of State Rubio has articulated zero in that regard. And that's what we'll be asking the judge to review, because she has the right to review whether there's serious grounds to support the accusation in this case.
Thank you both. I'm now going to move on to a question from Gloria Pazmino at CNN. Please talk more about the evidence that was submitted by the government. Is the Rubio letter the only thing? And if so, what does that tell you?
So they have submitted, this is the Rubio letter is the only piece of evidence going to the main charge in this case, that is, President of the United States could have potentially serious foreign policy consequences. There is zero else. They've submitted bunch of other paperwork on these bogus charges they added later on, about alleged misrepresentations on applications and things that he's been involved in negotiations that he was involved in at Columbia with the administration and the protesters. But it is zero to do with the foreign policy charge, and there is zero support for the government's allegations about any misrepresentation. We'll be dealing with that in court tomorrow, assuming we get to that. But there's no there at all, so we're not concerned with that at all.
Thanks, Mark. The next question is from Reuters, and it's regarding bond. The question is, have you or will you file for an immigration bond? And if Judge Comins terminates the case with or without prejudice, is that appealable in your view to the BIA? And this came from Jonathan Allen.
So in immigration court, it's the government's position that if a non-citizen falls within this foreign policy ground that Mark has been talking about, they are ineligible for bond. An immigration judge can't even consider whether to redetermine the custody of that non-citizen. And so as of right now, the government seems to believe that the immigration judge is constrained by this regulation. The regulation, is violative of the immigration laws. It's certainly in violation of the Constitution. And that's why in habeas proceedings, one of the pending motions is bail for Mahmoud, because the immigration framework as it's set up currently doesn't actually ensure that his right to have his custody redetermined is fulfilled. So this regulation essentially counters our understanding of how custody is supposed to work in the civil context. There's really only two reasons a non-citizen can be detained, either because they're a flight risk or a danger. But the government's position is that that's all irrelevant, so long as, there's an assertion that they're subject to the foreign policy ground, which is straight up unconstitutional. And again, that's being challenged in the habeas proceedings.
Thanks, Johnny. The next question is from WNYC. Based on the judge's prior statements, has she given any indication of how she plans to rule in Mahmoud's case?
She has not. She hasn't seen any evidence. But given her statement in court on Tuesday that, she didn't seem to be able or willing to look very favorably on a request to subpoena Secretary of State Rubio to say, what's the story here? Where's your evidence? We hope she will change her mind and hope she'll understand that has to be done. But we really have no idea. We are hopeful that she will agree there's no evidence, and if there's no evidence, she should terminate the case, and he should be released. But whether she'll do that, we'll see tomorrow or beyond, depending on if we actually finish tomorrow. But I thought maybe Bahar, you might want to sort of add on about the bail issue, perhaps, and what we're going to do in what the federal court.
Yeah, there's some questions in the chat about what's left to decide in the federal court, and one of the urgent motions we have before the court, and that we've repeatedly asked the federal judge to address, is one, a motion for bail that would have the federal court order Mahmoud released from custody, and also a motion and that would be, I think, the most important relief, alternatively, and at a minimum, a motion to transfer him back to the jurisdiction of the court, which would certainly not ideally have him confined in Elizabeth, but at least in a place where he could regularly meet in person with his lawyers, and most importantly with his with Noor, his wife. And then more broadly, we are seeking to have the federal court rule that the application of this provision to Mahmoud, and even more broadly, would be unconstitutional. So we hope the court reaches the bail motion soon. He knows we're eager to have it heard.
Thank you both. Relatedly, I think we covered a little bit of this, but want to make space for if there's anything others want to add. Stephanie Palma from the Financial Times has asked, you talk about what would happen if the judge finds Mahmoud is removable. Could you talk about what would happen if she finds the evidence does not support his removal? Additionally, and I think we covered this a little bit, but Bahar, if you have more to add, please do. How do potential outcomes in immigration court then impact proceedings in federal court?
So just very briefly on the immigration aspect of it, if she were to find the government hasn't met its burden of proving by clear, convincing, and unequivocal evidence that he is deportable, she has to terminate the proceedings and he would be released. Now, the government would have the right to appeal, but we would be immediately arguing for his release, and we would expect that to happen.
And the other part of the question is what happens in his federal case if he is deemed not removable?
Yeah, slightly more general than that. So how do potential outcomes in immigration court then impact proceedings in federal court?
Well, very importantly, this habeas corpus proceeding in federal court is independent of the immigration proceedings because, anytime someone is in custody of the executive branch and that custody is unlawful, even if the executive branch and the immigration courts are unwilling to make that determination, the federal court always has the power and the obligation to decide the legality of the detention and order the person released if they are, if the court determines they're unlawfully detained, which we obviously think is self-evident. So we're moving on both fronts and recognizing that we have the most powerful arguments and the most powerful audience in federal court.
Thanks. I'll try to get in two more, and then I think folks have to jump. So again, thank you all. And I'm sorry if we didn't get to your question, but we are trying to cover as much ground as possible and combine themes. The next question is from Tanvi Misra. Their question is, I understand it is the government's burden at this point to prove that Mr. Khalil is deportable in immigration court. Do you think they have met that burden with this memo? There were also some questions in the chat about what that burden is in immigration court. So if folks could answer that as well. I'll pause there for answers to that, and then I can ask the rest of the question.
So,
You want to take that?
Yeah, sure. The government's burden, they have to meet what's called a clear, convincing, and unequivocal evidentiary standard. So it's very high. We think that they've fallen well short of meeting their burden. As Mark has said several times, and many people may have read, the Rubio memo is completely devoid of any factual recitation as to why exactly Mahmoud's presence in the United States is adverse to a compelling U.S. government interest. There's absolutely nothing there in the letter itself, and that's all the government has provided in order to establish the foreign policy ground. Now, the government will take the position that all they need to do is submit this letter. Clearly, they believe that because that's all they filed. But our counterpoint is that, absent some testimony from Secretary Rubio as to what actually formed the basis for his determination, they have not met their standard at all, and the judge would have to terminate proceedings. Now, the Rubio memo references several attachments, but those attachments weren't given to us. They weren't submitted to the court. They may even include exculpatory evidence. We don't know because we haven't seen it. Clearly, there was some reason why the government hasn't filed it. And so again, we think that they have woefully failed to meet their burden.
And I would just add to that, that the Rubio determination is, the statute says that he had to personally make this determination. personally. The evidence is clear that DHS, ICE submitted things to him, asked him to do this, and that's what he did. And he, the Rubio determination says that basically he found him deportable. Well, that's not for him to decide. He can make that allegation, but the immigration judge is the one who has to decide that. And we're going to be trying to convince the immigration judge of that tomorrow.
Thank you both. We have a question that I think is fitting to end on, but depending on how long it takes, I'll try to sneak in one more if we can. And it's a question about what this means for others in similar cases. Does the fate of Mahmoud's case and tomorrow's ruling possibly have implications on other cases that we are seeing right now? And that was a question asked by various outlets, including Newsweek.
Yes, I think that's very much why we are all here and why we recognize the sort of page-turning threat to our constitutional rights. And if the Secretary of State claims the power to arrest, detain, and deport someone, including a lawful permanent resident, simply because that person dissents from U.S. foreign policy, there are no limits. There's no beginning and no end to that kind of executive power. And the reason you all are here, I think, and the world has paid so much attention to this case is because of its really dramatic implications. This is not a routine immigration case or even routine habeas case. This case is intentionally projecting a message of repression about who can say what in this country and the consequences to your liberty and your life if you object to U.S. policy.
And this will be our last question. It's from Dave Nakamura at the Washington Post. Attorneys for Mr. Khalil and other scholars detained in Louisiana and Texas have said they object to those detention centers in part because they are located in the Fifth Circuit. Do you believe immigration courts there are also more conservative than in other parts of the country? And are you concerned that they will unfairly burden Mr. Khalil? And do you see the speed in which this judge is acting to rule on his case reflecting anything one way or the other?
I'll take that. So as to the first part of the question, the Immigration Service has been sending people to remote detention facilities for several years. They, in my opinion, they do this for many reasons. They do it as punitive. They do it to remove people from their place of support, whether it's emotional support from their loved ones or their legal support, and they are forum shopping as to where they want the case decided. That has been clear, and certainly clear in this case and the other individuals who recently have been shipped off to faraway locations. As to the, and I'm sorry, I'm forgetting the second part of the question now.
That is what I'm here for. Give me one moment. Do you see the speed in which the judge is acting to rule on his case reflecting anything one way or the other?
We were shocked that on Tuesday, the first hearing in this case, the immigration judge said, I'm proceeding to trial in essentially 72 hours. And that is, in my opinion, abhorrent. It is contrary to every notion of due process. We have a right to to see the evidence, confront the evidence, respond to the evidence, and to have this rush to judgment has no place in our court system at all, whether it's immigration court or anywhere else. We are going to renew our motions before the court to give us a reasonable time to consult with a client, to present evidence, to subpoena the Secretary of State. We are hoping she will have a different attitude than she had on Tuesday, but we'll see tomorrow.
And I think that's a great note to end this session. So I wanted to thank everybody for joining. Thank you to Bahar, Johnny, and Mark. Folks that are also tuning in, we will have a recording of this available to you as soon as Zoom makes it available to us. So bear with us as the file downloads and buffers and whatnot. And we will be in touch tomorrow. I am extremely confident in that. So stay tuned. You know where to reach us. And thank you all for joining.
Hey.